was in East London and attended the event, and he was also said to be on stage. Therefore, it is also without reference to video clip 3 that he had left the firearm in Gauteng. Therefore, he was no longer in control of the firearm that was booked out to him for his use when necessary. Accused 1 departed from East London on 30 July 2018, a compliance letter in respect of tactical services as mentioned. Therefore, in essence, all of the above facts remain without needing the viable footage to support these facts. Further, all firearms checked by the ballistic unit as per batches received and returned remains unchanged, that a toy or movie gun may emit muzzle flash. DNA and fingerprints were not linked to Mr. Malema or, if tested, are to accused 2. Therefore, again, the only aspect to be determined is whether the rifle fired by Mr. Malema was a real firearm or not, and the court is of the view that the viable footage is not needed to enable the court to arrive at a finding in this regard. As a side remark, it should be noted that the very same viral video footage was used by the defense to indicate certain factors they wanted to be placed on record, and in the same breath, the court is asked to rule that the viral video footage is inadmissible based on the fact that the originator of the said footage was not traced and called as a witness. Therefore, even though the court ruled the said footage as real evidence, as it is relevant, but it should be excluded as it was not authenticated. This leaves the question as to why the defense relied on the footage during their cross-examination of the state witnesses to emphasize certain factors or facts, and it was also used by the defense during the presentation of the defense case in respect of accused 1. Further reasons that remain without reference to the viral footage is the Gear House company footage was downloaded on a hard drive which was kept safely under lock and key by Mr. Singh. He was the only key holder of the said safe, and it was only unlocked when the officer from ballistic unit arrived. The procedure thereafter as to the downloading by the various individuals placed on record as per facts was confirmed in evidence that it is indeed the recording recorded by Gear House, and that the snippets that was viewed regarding clip 1 and 2 was indeed part of the recording that was recorded. I will admit and mention the Gear House footage is not as visible as the viral footage. But in this regard, therefore, the Gear House footage is ruled as a real evidence, it is relevant, it was authenticated, and therefore it is ruled admissible. With regards to the viral footage, I've stated the facts which the court will rely on without giving any real regard to the viral footage, and no further finding is required regarding the said footage. Please bear with me. As I said, I tried to summarize all in less quantity. Therefore, the court will now reach findings regarding the credibility and probability findings by the court in respect of the state and the state case. Firstly, the state witness that testified before court are found based on the evidence placed on record yesterday and the day before to be credible, reliable, and truthful, and the court cannot find any bias, prejudice, or any motive in the evidence of any of the state witnesses to indicate otherwise. Mention needs to be made with regards to the evidence of Colonel Mbadlega. Safe to say that he was a brilliant witness and had left no stone unturned. He had dotted every T and dotted every I. He had not made any mistake as far as the custody chain or the handling of the exhibits or the serial numbers contained. The court finds him and all the above then as stated credible, reliable, and truthful. However, the evidence of Colonel Mbadlega during his testimony was checked in the working case file which the defense had insight of. And with reference to the evidence of Colonel Mbadlega, the court has placed the procedure regarding the evaluation of expert witnesses on record already. He meets the criteria. In fact, he exceeds the required criteria in his thoroughness, and he can be, or he is mentioned by this court to be not only an expert witness, but a super qualified expert witness. That is the conclusion regarding Colonel Mbadlega. I've already dealt with the gear house and the admissibility. However, I want to emphasize that the further aspect regarding the laptop that was stolen and mentioned as a reason, the stealing of the laptop is a non-event. It does not affect the chain of evidence regarding the gear house. The gear house starts where it was confirmed by the employees that the hard drive was indeed depicting the correct footage they recorded. Thereafter, they cleared for space for future events. Therefore, the theft of the laptop is neither here nor there. It's not a factor this court needs to consider. Now, in dealing with the defense case, the following is placed on record during the evaluation. The evidence of Mr. Wood is noted and greatly appreciated by the court, including his extensive knowledge with regards to the provisions of Act 60 of 2000, and it is so acknowledged by court. With regards to Mr. de Klerk, as per the cited requirements already placed on record in the evaluation of expert evidence, and specifically with regards to, I emphasize, the personal knowledge of the subject stroke exhibit. He did not examine the cartridge or the said SPA 24914. Further, he had examined all the other firearms and rifles which are not relevant to this case. Therefore, it is noted, and that is the only finding I can make on those tests conducted. However, it needs to be noted that during cross-examination, the witness was indeed a defensive witness and at stages argumentative. His evidence mostly relates as to, and then he continues stating, if I can put it more clearly, the report deals with the evidence and how it relates as to what the microscopic examination entails, or should entail, and all exhibits thereafter is not relevant to the case. He states, in the matter before court, the witness testified that he used his mere eye or magnifying glass. Therefore, he also mentioned the second ballistic expert present in court. I must highlight this was the second expert was not called, so it is really with regards to cross-examination regarding the two ballistic defense witnesses present in court is a non-event. It is disregarded as a mere statement placed during cross-examination. On evaluation of the evidence of Mr. de Klerk, the mere eye or magnifying glass can never stand or be accepted in the light of the ballistic expert witness, Colonel Mngwadleka. It falls short and can only be noted as mediocre. However, I do not imply that he is not an expert in his field, but highlight the fact that also he did not receive peer review, and at times his answers in cross-examination was extremely sarcastic, and what comes to mind was on being questioned regarding the amount of cases finalized by or examined by Colonel Mngwadleka compared to his response was, I quote from memory, good for him, consider the years of his service at SAPS and then you compare it to my years of service at SAPS. And in event, the witness left the services of SAPS approximately 30 years ago. That is all that can be said regarding the evidence and the defense case on behalf of accused two. No positive findings is made in respect of the exhibit A. With regards to accused one, on evaluation, it was evident that the only aspect to be decided on was whether he fired a real or toy gun. The said firearm, toy or real, was indeed handed to him by Mr. Mavundla, and during his evidence he testified that Mr. Mavundla should have been charged. This begs the question, charged for what? Handing you the toy firearm or then alternatively the SPA 249-14? The answer is nonsensical as to why Larry Mavundla should have been charged. In effect, the further particulars indicate a warning statement was obtained from Larry Mavundla as per A121. And just to elaborate on one aspect, sorry, I need to revert to the defense case on behalf of accused two. Apologies, number one. It also comes to mind that Advocate Matthews had put to the witness that being Colonel Mngwadleka, he had received instructions from the said protecting officer, being Larry Mavundla, that the breech block of CN SPA 249-14 has not been changed or altered in any manner. Now that statement remains a mere statement. The person on whose instructions Advocate Matthews placed this statement to the witness was not called to substantiate. Therefore, it is a mere statement done in cross-examination. It also further then begs the question, if he had left the firearm in Gauteng as stated, he cannot make such a version or instruction to Advocate Matthews because in his version or their version, he had not possession of the firearm during that time. Now, to return to accused number one, I've dealt with as to why he states Mr. Mavundla should be charged. He also relies on the video footage of clip 3. I mentioned this as a mere reason that it was part of his evidence, and he identifies Mavundla, who was not called to testify, and identifies Chauke. Now when read this statement regarding identifying Chauke, read with Chauke's evidence or statement that he was not on the stage or present on the stage, leaves a question mark. During cross-examination, which I've already placed on record the aspects, the evaluation is as follows. Mr. Malema had evaded many questions that had warranted a reply. It became evident that the replies were entertaining, but however, the pertinent questions asked remained unanswered. He further relied on clip 3, and he had then counted 15 shots fired, and thereafter stated he cannot count, he had graduated in woodwork. Further, as to how the cartridge or the SPA 249-14 is linked to him, his reply was it must have been the Holy Spirit, and these type of answers did not do accused one any favors. In essence, when one is questioned in the witness stand and a mere question is asked from you which elicits a response, one would expect that the question will be answered. Therefore, the court needs to deal or to establish whether the version presented by the defense is reasonably possibly true. I have already stated all the factors that remain intact, excluding the video clip 3. Put me under pressure when it's time limit, so I just need to split up my documents here. Now, the court will proceed with the findings made in this matter. And as stated, the findings are based on the rules pertaining to circumstantial evidence, keeping in mind the two cardinal rules already placed on record, but which the court will repeat at a later stage. Firstly, the inference, or it can be said that all the relevant persons as per the evidence of this entire case were in East London, that the firearm booked to Mr. Mavunga was, according to him, not in his personal possession, but no explanation has been given as to where it was kept in Gauteng. The registers of the KZN unit indeed states it was booked out to Gauteng Larry Mabunda. But where was it kept since 28 July or since his departure in Gauteng? Mabunda, through Advocate Matthews, informed him that the breech block was not changed or altered. And now, if he left the SP249 in Gauteng and came to East London, it was not in his personal control as stated. However, the question is seen as a mere question put in cross-exam and remains just that, the statement in cross-exam. Therefore, the person who informed Advocate Matthews of this fact then should have been called, and he is in no position to give such information since it is his version of the defense that the firearm was in Gauteng. Now, as to what happened and where it was kept, no explanation was provided. It begs the question, dealing with circumstantial evidence, that what does the firearm being booked out to Mr. Mavunda in effect equates to? That specific firearm is booked out to him for whenever it is needed for him or by him, since clearly it does not mean it needs to be on his body since he left it in Gauteng. Further, on considering those aspects, why would the two firearms in question be called in and said it is please take this for ballistic testing? However, the others that were booked out in the register was not brought in on the day Colonel Jansen left on the 6th. Just the two in question. Further, the court is obliged to look at that the said cartridge was found, as the evidence was accepted of Colonel Wadlega. It was matched with SPA 249-14, and the conclusions on the record by Wadlega have already been placed on record. And since I'm pressed for time, also further, accused one says he is the only person who fired an object resembling a firearm, no one else. The grounds were inspected the morning of the event and no cartridges were found, and the area was declared safe. Therefore, the two cardinal rules for the court to draw inferences on the evidence presented, and which I have now stated on record as a reasoning as to the reasons why the court has arrived at its decision. I remind you with caution the cardinal rules being, firstly, that the inference sought to be drawn must be consistent with all the proved facts, and secondly, the proved facts should be such that they exclude every reasonable inference from them save the one sought. In this instance, the question or the pertinent question then remains whether the court can infer, based on the reasons placed on record, including the evidence that it had dealt with over the last 2 days, whether such inference can be made. And the court finds as follows: indeed, the inference sought is supported by all the facts contained as per the evidence presented in court, and therefore the following findings are made. You may stand up, accused 1 and 2. Accused 1, in respect of counts 1, 2, 3, 4, and 5, you are found guilty as charged. Accused 2, Mr. Snyman, in respect of counts 4 and 6, you are found not guilty and discharged. You may be seated.
Take the floor.
Something you wanted to place on record?
Yes, Your Worship. I just wanted to say accused number 1 is no previous conviction.
Same is noted.
At this stage, because of the shortage of time, my instructions are to apply for disbarment and for the continued release of the accused on warning. He's been on warning since the outset and has always appeared in court.
The court has no intention of changing the status of your client, so I'm completely in agreement with that, and further that it's not possible to deal with the rest of the proceedings today.
As we should please speak to that. In that regard, Your Worship, it's our intention to obtain a pre-sentence report. And for that purpose, we need to arrange a date. Because Your Worship will be calling from.
At this point, just so that you may have a word with your client regarding his schedule, of course, Advocate Matthews, you are now excused from record.
I'm going to catch my train.
You are allowed to do so.
But let me say something to you. I just want to thank you because you have been very patient with us. And you have, on many occasions, allowed the case to continue without us being present.
Thank you, Advocate Matthews. It's much appreciated. Mr. Snyman, it will be your choice whether you stand down and leave Mr. Malema or if you want to remain seated next to him.
I'll remind you.
Sorry?
I'll remind you.
Alright, I assume as much. Just to take instructions regarding the time frame, suitable date, whatever I have on a specific day, obviously I will have to clear or deal with as I had to do yesterday and today. So may I leave you with that arrangements and then return, it's 20 to 11. We'll return by 10 to 11. Is that in order?
Thank you.
Well, I
As to what was said, I just need to introduce Thank you. I'm ready. I think you had installed the position that before that the defense, please proceed, is going to opt for the pre-sentence report. I just want to endorse that is the position. I have endorsed that. You could see that no previous convictions. In case you wanted, if I've endorsed it.
There's a court case.
Advocate Owen, may I just inquire on this pre-sentence as well? Will it be, you be following the normal route that is followed, or will you be using your own?
Our own private practitioner. The signals graduation, but I attempted to get hold of Mrs. Ian Thompson because that's a fortune good and was qualified with an LLB and in social work that
The reason why I'm asking is merely so that the clerk of our court will know whether she should prepare a request for the normal route. But now that has been ruled out and the defense will do so on its own.
we accept responsibility for the compilation of the pre-sentence report. My learned friend had also tried to assist in that report, Bishop, and also the accused details and explained to me because the necessary will be pursuing our own private social worker to present a pre-sentence report.
Anything else?
Yes, Worship. To that end, Worship, subject to your Worship permission, we've agreed to the date of Friday, the 23rd of January 2026. But we provide sufficient time to compile a report and fit in our respective diaries. I don't know about your Worship.
I don't have it with me, but I know January starts quietly because practitioners are still on vacation, but I do have a matter, but I can deal with it and accommodate this matter as I've been doing, so it's not a problem.
That's truly appreciated. Thank you.
Thank you. And today is suitable for the state advocacy.
Suitable.
Mr. Malema, the matter is then postponed.
I'm fine.
procedure, but fine. And then if you fine, I'm fine. The matter is postponed to the 23rd of January for the pre-sentence reports. Now, in this regard, I want to place on record, I am not sure as to whether the defense, being Advocate Otis and yourself, will be leading evidence or calling witnesses in that regard, and then the state to address. So, depending on how much time is utilized in that process, I cannot say sentence will be pronounced on the same day. It depends on what you will be presenting before court on that day. Therefore, bail extended, warned 9 o'clock to proceed, 23 January 2026.
May the court please.
Thank you. The court is adjourned. Then I will continue with my normal role for the day.
Salamé.
Thank you.